Students, for today's lecture, we're going to talk about civil liberties. Civil liberties, these are the protections found in the Bill of Rights, those first 10 amendments. These are protections from the government. So under this lecture, well, for this section, we're going to talk about nationalizing the Bill of Rights, the First Amendment, freedom of religion, speech, press. We'll talk about some court cases regarding those. But the First Amendment also deals with freedom of assembly or to petition the government. Then Second Amendment, the right to keep and bear arms. The Fourth through Eighth Amendments, these are the rights of the criminally accused. And the Ninth Amendment, this is our right to privacy. So let's start off with discussing nationalizing the Bill of Rights. Bill of Rights, first 10 amendments found in the U.S. Constitution. Offer us various protections, search and seizure, freedom of speech, religion, that kind of thing. Well, I want to talk about something in the Fifth Amendment, eminent domain. Eminent domain is the government's ability to take property, to take something from you. Can the government do this? Yes, they can, but they have to pay you for whatever it is they're taking, and they have to pay you fair market value. If we look at Barron versus Baltimore, 1833, Mr. Barron owned a profitable wharf, Baltimore Harbor. A wharf is a long pier or an area where ships will come in, unload cargo, pick up new cargo to deliver elsewhere. They pay for the privilege of doing this. So this was Mr. Wharf's primary source of income. Well, the city of Baltimore goes on basically the city improvement spree and clean up their streets, all this nice stuff. And when they get done, they have all these huge piles of debris that they don't know where to put them. So the city decides that they're just going to dump this debris in the streams around the city of Baltimore. Well, these streams are these streams are what provides water for the wharf, for the harbor. What happens when you slow water, when you change the course of water? Not as much is going to get into the wharf. The wharf is going to dry up, is going to become more shallow. So this means that the ships can't get in to drop off and deliver, or to deliver and pick up cargo. This means Mr. Barron loses his money. Well, Mr. Barron sues Baltimore, the city of Baltimore, for this choice. Says, hey, this is Fifth Amendment. You took my property, you took my business. You must compensate me according to the Fifth Amendment. Well, the city of Baltimore says, no, we don't, because the Bill of Rights, the U.S. Constitution, only applies to the federal government. It does not apply to the state government. Does it? The trial court agreed with Mr. Barron. They said, yes, Mr. Barron, you're right. They took your property. We are awarding you $4,500. Remember, once again, 1833, this is a lot of money. Baltimore appeals. The appellate court sides with Mr. Barron. Baltimore appeals. The case goes to the Supreme Court, where the Supreme Court rules in Baltimore's favor. They say that the Bill of Rights limits only the national government. It does not apply to the states. Now, is this what was intended when the framers created the Constitution, when we ratified the Bill of Rights? Was it created to only apply to the federal government? Thought process is no. So we're going to try and fix it. We see this with the passage of the 14th Amendment in 1868. 14th Amendment, it does three things, and each item is actually very important in regard to civil liberties. It's important in regards to civil rights. But let's look at it and break it down into three portions. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is the first portion of the 14th Amendment. We call this the Privileges and Immunities Clause. What this portion says is that any rights or any privileges that are granted by the United States federal government, they have to be honored by the state government. So any rights granted by the federal government have to be granted by the state government. Next one, that not shall should be nor. That's a typo. Nor shall any state deprive any person of life, liberty, or property without due process of law. So due process clause just says any legal protections you're entitled to, you get, whether this is a trial by jury, this is an attorney to help you. Due process clause. We are entitled and we receive due process, or we receive our court protections. Last one. Nor deny to any person within its jurisdiction the equal protection of the laws. This is the Equal Protection Clause. This was created, we are trying to make sure that the recently freed African Americans were receiving the same benefits as Anglos. So what this was trying to say is that if it was legal for Anglos, it was legal for African Americans. Equal protection. Today we can say if it's legal for one, it's legal for all. Now, we ratified the 14th Amendment in 1868. Does that mean that all the states accepted it in 1868? The answer is no. Even though we ratified the 14th Amendment, and that first section, the intent was to make the Bill of Rights apply to the states along with the federal, we see the states, we see us, go through something called selective incorporation. Selective hearing, you hear what you want. Selective memory, you remember what you want. Selective incorporation, we are going to incorporate the rights that we want. This was a slow process for the states to finally accept the entire Bill of Rights, even though they were supposed to in 1868. 1897, we finally see the states accept you cannot take property without compensation. 1925, freedom of speech is applied to the states. 1931, freedom of the press is applied to the states. 1939, freedom of assembly is applied to the states. So it took us an additional, 70 years from the ratification of the 14th Amendment for us to actually make the Bill of Rights equitable or occur at both the federal and the state level. Let's get into these rights, these protections that we have. First Amendment covers a number of things. We're going to start off with freedom of religion. First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Once again, we're going to cut this in half. Congress shall make no law respecting an establishment of religion. We call this the Establishment Clause. The Establishment Clause has been interpreted by the court to say that there is a wall of separation. The Establishment Clause creates a wall of separation between church and state. Now, what do walls do? Well, they're supposed to keep things out. So this wall of separation, it's supposed to keep the government out of religion. But remember, walls work both ways. It's also supposed to keep religion out of the government. Has this happened? Let's look at a couple of court cases, and these are older court cases, but these are still relevant into this Establishment Clause, the separation of church and state. The first is a court case called Engel v. Vitale, Engel versus Vitale. It was decided in 1962, and the question is school prayer. Should school prayer be allowed in public schools? This case originates out of New Hyde Park, New York. There was a voluntary prayer written by the State Board of Regents. It was read every morning, and the prayer went, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. What's wrong with that prayer? What was the complaint? The complaint was how the prayer starts off. It is addressed to Almighty God. God is the deity that is recognized by the Christian religion. While other religions have their own major deity, they are not referred to by the name God. Also, what if you're an atheist? What if you're a non-believer? This was the complaint. This prayer, by praying to God, this prayer boosted Christianity over all others. In a 6-1 decision, the Supreme Court agreed. They said this was a violation of First Amendment separation of church and state, the Establishment Clause. So 6-1, no school prayer in public schools. Next case, Lemon versus Kurtzman, 1971. What we see is that when the courts are trying to decide if words or actions are constitutional or unconstitutional, they will attempt to create a test. This one is going to be the Lemon test. The background on this case, it comes out of the state of Pennsylvania. The superintendent of public schools in Pennsylvania, their entire state is run by one school entity, not like Texas, where we are broken up into school districts. So this means that there is one person, the superintendent of public schools. He is in charge of all of the public school kids in Pennsylvania. He looks at how they are doing, and he, like any other superintendent, teacher, or anything like that, says, our kids are doing good, but they could be doing better. How do we get our kids to do better? Like today, we believe that if the kids spend more time in school, they will receive a better education. They will do better in school. So the superintendent, he wants after-school programs, he wants more tutoring. He goes to the state legislature, he explains his program, he explains his plan, and the state legislature agrees. And they pass the, the name is the Non-Public Elementary and Secondary Education Act. What is going on? What has led up to this? The superintendent has asked the public school teachers if they would be willing to stay after school and tutor. The answer is no, we do not want to stay past the time our contract calls for. So he has to look for teachers from somewhere else. If you can't find public school teachers, where are you going to find your teachers? Private school teachers. So he goes to the private schools to see if he can hire their teachers, to see if he can hire these private schools to provide their teachers as tutors. Well, when you say private school, most people tend to think of private school has certain connotations, certain inferences. When you think of private school, you tend to think of religious school. Well, when you think of religious private school, we tend to think of most religious private schools are schools provided by the Catholic religion. So he went to the Catholic schools and said, can I hire y'all to provide teachers to our students? Catholic churches said, sure, yeah, we'll do it. We'll hire us, pay us, and we'll pay them. So we have the funding. He hires these teachers from these private Catholic schools to come in and teach. Why would people get upset? I mean, they're there to teach the kids, to make them smarter. So what would be the issue? Well, once again, what are they teaching? Are they teaching Catholicism? Are they teaching Christianity? All of these good things. All of these are questions raised by atheists, raised by those who practice another religion. So the case goes to the Supreme Court, and the court is trying to decide if this non-public, whatever I called it, act, Non-Public Elementary and Secondary Education Act, is constitutional or not. So the Lemon Test. Court creates the Lemon Test. There's 3 prongs, and the court says it has to pass, the law has to pass each test to be considered constitutional. So the first prong, the program must have a secular, a non-religious purpose. What was the purpose of this law? To tutor the public school kids, religious or not religious. Not religious. Pennsylvania's okay here. Second prong. The primary effect must not be to advance or inhibit religion. Okay, so how can we be sure that these Catholic school teachers aren't trying to advance the Catholic religion? Pennsylvania says this is very, very easy. This is very, very simple. They are not allowed to bring any material into the classroom with them. They have to tutor from the material that the school provides. Since it is already provided by the state, we know it is secular, we know it is non-religious, so they are not trying to advance the Catholic religion. Supreme Court says, okay, that's reasonable. Third prong. It must not entangle the government excessively with religion. And this is what catches Pennsylvania. What the court decides is that while 75% of these kids and of the students in Pennsylvania go to public schools, 25% go to private school. But all the teachers hired, there's 250 teachers hired under this act, all of the teachers came from Catholic schools. This means that the Catholic schools, the Catholic religion, was getting 100% of the money. To the court, this says this is going to be excessive entanglement with religion. Because Catholicism was getting the entire pie, it was like the school district, or excuse me, the state government was favoring Catholicism over all others. So this act passed by Pennsylvania was unconstitutional. The second half of First Amendment freedom of religion: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So this or prohibiting the free exercise thereof, we call this the Free Exercise Clause. Does this mean exercise is free and that gyms can not legally charge you membership fees? No, it doesn't. Not at all. Free Exercise Clause, what it means, it protects the right to believe and practice whatever religion you choose. Catholicism. You can be Methodist, Lutheran, Episcopalian. Practice the Jewish faith, practice the Muslim faith, be a Hindu. You can believe and practice whatever religion you want. Or you don't have to practice any. You can choose to be a non-believer. You can choose to be an atheist, and the government cannot do anything about it. However, be careful. There are some limitations. There is a distinction between religious beliefs and actions based on those beliefs. So if your religion calls on you to perform an illegal act, can you perform this act and a valid defense be, look, I was practicing my First Amendment freedom of religion. It is what I believe in. I acted on my religious beliefs. You cannot prosecute me for that. No, you are wrong. Your actions are not covered. Your beliefs are covered, but this does not mean you can perform illegal actions. If you perform any illegal actions while practicing your religious beliefs, you can still be punished. Continuing First Amendment, but now we're talking freedom of speech. I'm going to talk about a court case, Schenck versus the United States, decided in 1919. The year of the decision, 1919, is important for context. What was the United States involved in, or what were we finishing up in around 1919? World War I. So in Schenck versus the United States, Mr. Schenck is a member of the Socialist Party. He is on the executive board of the Socialist Party in Philadelphia. The United States is fighting in World War I. How did we get our troops back in World War I? Conscription. The draft. We were drafting young men to go fight this war. Well, Mr. Schenck and the Executive Party, they have 15,000 flyers printed out and they send these to these young men who are receiving these draft notices to not report for the draft. They are encouraging to avoid reporting for the draft. Well, Mr. Schenck and his friends are arrested, they are charged with violating the Espionage Act of 1917. Mr. Shank's defense is freedom of speech. Government, you may not like what I'm saying, but I have the right to say it. The trial court disagrees. They agree that the government can prosecute Mr. Shank under this Espionage Act, that they are not violating his freedom of speech. The appellate court agrees. The U.S. can prosecute Mr. Shank. It's not a violation. So it goes up to the Supreme Court. So for the Supreme Court to decide if we're talking something is constitutional or unconstitutional, they create a test. They call this the clear and present danger test. The clear and present danger test, a lot of words. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So the clear and present danger test. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. The court, in a 9-0 ruling, they upheld the Espionage Act. They upheld the United States' ability to prosecute Shank. Their argument was, Mr. Shank, you are sitting here, or excuse me, not their argument, their decision, is, Mr. Shank, you are encouraging men to not report for the draft. By reporting for the draft, you are encouraging these young men to break the law. Because you are encouraging men to break the law, your silence, your speech can be limited. How would encouraging them to not report for the draft, even though this is breaking the law, how else could this affect Congress? How else could this be viewed? Well, without men, we don't have an army. And without an army, we don't win wars. So does Congress have the right to prevent you, to stop you from telling men not to report for the draft so that we can have an army so we can win these wars? Yes, they do. That's the old version. This is what was said in 1919. We have updated it. The updated version of this, the modern version or the modern explanation is, can you legally go into a crowded movie theater and yell fire? If it's untrue. If it is untrue, can you do it? No. Why not? You go into a crowded movie theater, you yell fire, people are going to try and stampede out. They're going to try and leave. It's going to cause a stampede. People are going to be injured. They may even be killed. Does Congress have a right to prevent this injury, this action to these people? Yes, it does. So that's the clear and present danger test. The next case, Brandenburg versus Ohio. Decided in 1969. Mr. Brandenburg is a member of the local KKK. They are having a meeting. They're having a rally in Hamilton County, Ohio. And Mr. Hamilton decides he wants to invite the media. Not Mr. Hamilton, I'm sorry. Mr. Brandenburg decides he wants to invite the media. So he calls this news station from Cincinnati, says, hey, we're having a KKK rally on this date at this time. Would you like to send somebody down to report on it? So the news station says, sure, we'll send somebody. So they send a cameraman down. Cameraman records like cameramen do. The reporter reports like reporters do. They finish their report. They go back to the station. They edit their report and they show it on the nightly news. Well, as they're there, the cameraman, the cameraman, the reporter, they're recording everything going on. And they record Mr. Brandenburg in his hood and his robe, standing up in front of the crowd, cross burning behind him. And they record his speech to the crowd, where Mr. Brandenburg saying things that you would normally see at a white supremacy rally. He is saying things like white power, white nationalism, white is right, segregation is the natural order of things. To our politicians, if you support desegregation, we will not support you. We will not vote for you. Talks about they're going to have a national march in Washington, July 4th. Just this kind of thing. Well, like I said, the report is edited. It goes out, shown on TV. And based on this speech, Mr. Brandenburg is arrested. Ohio has what is called a criminal syndicalism. SYNDICALISM. A criminal syndicalism. SYNDICALISM. Statute. What this statute says, the important part, the relevant part, it prescribes advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. What this says is that you cannot encourage violence as a means of political reform. So this is what he's charged with. Violation of this criminal syndicalism. Mr. Brandenburg says, sorry, defense, freedom of speech, I can say what I want. Government, you may not like it, but I can still say it. The lower court agrees with Ohio. Mr. Brandenburg is convicted of violating the statute. He's fined $1,000, sentenced to 1 to 10 years in jail. The appellate court upholds the lower court's decision. So Mr. Brandenburg's case is accepted by the Supreme Court. Supreme Court gets this case, and to decide constitutionality, they are going to create a test. This one is called the direct incitement test. The direct incitement test, we're looking at the words used. We're looking at intent. We're looking at the big picture. With the words you choose to use, with your words, imminent lawless action is intended and likely to occur. This is the direct incitement test. Imminent lawless action is intended and likely to occur. So if you say something with the intent of having somebody break the law, and it is likely that they are going to break the law, yes, you can be punished. The government can they can limit your choice of words. Did Mr. Brandenburg's words rise to this level of imminent lawless action is intended and likely to occur? Think about what he said. Now, it wasn't good, but he said things like, white power, white supremacy, segregation is the national order of things. If any politician supports desegregation, we won't vote for you. Any of that, if any of those words, did Mr. Brandenburg indicate he wanted lawless action to occur? Was it intended? Was it likely to occur? Did he advocate for any lawless action whatsoever? No, he didn't. So on an 8-0 decision, the court ruled that Ohio had violated Mr. Brandenburg's freedom of speech, thanks to the direct incitement test. Symbolic expression. Symbolic expression is one that people seem to feel strongly about one way or the other. There's very few that are in the middle on symbolic expression. Is it legal to burn a flag at a political protest? Yes or no? Is it legal to burn a United States flag at a political protest? The answer, yes, it is legal. The Supreme Court has ruled that flag burning is protected under First Amendment freedom of speech. It is considered symbolic expression. Symbolic expression are actions designed to send a political message. So it is perfectly legal to do this. Freedom of speech. We're going to cover something now. We're going to cover obscenity. Obscenity, the big takeaway, the main thing you have to understand, obscenity is outside the bounds of constitutional protection. Obscenity is not covered. But we have a problem. What is obscene? If I ask everybody for their definition of obscene. Now remember, obscenity can apply words, symbols, pictures, acts, noises. Obscenity can apply to a number of things. If I ask you for your definition of obscenity, how would you describe obscenity? What would you say? What threshold would you have to reach for this act, words, whatever, to reach the threshold of obscenity? And I ask you to write it down. Write it down. Think about what your opinion is, your definition. Now, if I go around and I ask everybody in a room to write down their definition of obscenity, then ask them to read their definition of obscenity. Do you think that everybody in the room is going to have the same definition? The answer is no, of course they're not. So, really, the easiest way for an individual to define obscenity is we can't put it into words. We can't say what obscenity is. However, I do know it when I see it. I know obscenity when I see it. This court case, Miller versus California, the Supreme Court is going to make a third effort to define obscenity. In Miller versus California, Marvin Miller is the owner-operator of a mail-order business specializing in pornographic films and books. He sends out brochures advertising for books and films that graphically show sexual activity between men and women. The brochures that were used in this mailing show these pictures. He sends them out to previous customers. Well, 5 of these brochures are placed in an envelope. They're mailed out, and they are delivered to the wrong address. They are delivered to this restaurant in Newport Beach, California. Well, California Penal Code, California law, has a law which prohibits any exhibits or production giving out obscene matter, obscene material. So Mr. Miller is arrested. He is tried under California law. But his offense, he says, up until now, if you look at these two previous court rulings, a portion of the ruling said that the activity, picture, whatever it is, in question could not have any social value whatsoever. There was no redeeming social value. He said, this is art, this is acting. These movies, this is acting, it has redeeming social value, therefore it cannot be obscenity. The trial court didn't buy it, the appellate court didn't buy it, and finally the Supreme Court. Their decision, 5-4. They're going to try and redefine obscenity. Speech or writing that appeals to the prurient interest, that is, books, magazines, film, and the like, whose purpose is to excite lust. So this is something, speech, writing, movies, whatever, that appeals to a person's sexual interest, as excites lust, as this appears to the average person, applying contemporary community standards, and any work that is utterly without redeeming social importance. So, now, trying to define obscenity, what does this mean? Who gets to define obscenity? This definition doesn't help at all. Who gets to define it? The average person applying contemporary community standards. Problem here is, how many communities can we have across the do we have across the United States? Hundreds? Thousands? So if each community gets to set their own standards, do we have a national standard? No. Once again, any work that is utterly without redeeming social importance. Who's going to decide this? The average person in each community. So, Miller versus California, in an attempt to define obscenity, they don't. They do not clarify it at all. We are still as confused as before. But they do say, okay, his argument that the acting in the movie is socially important, that could be a cause, so they send the case back down to the California court. They overturn the verdict. So Miller basically wins. First Amendment, freedom of speech. Actually, freedom of the press, I apologize. Couple of court cases here. For this first court case, you need to understand a term called prior restraint. Prior restraint is censorship before publication. The government cannot punish the media before they do something. They can't censor it or they can't punish the media before they actually run a story, before they actually present this news. So, the Pentagon Papers case, the Pentagon Papers, once again it took place, well, the real name is New York Times versus the United States, decided 1971. Once again, timing is important for context. We were involved in Vietnam. In 1967, we had been involved in Vietnam. We had lost a number of soldiers. In 1967, the Secretary of Defense commissions this top-secret history of the United States' role in Indochina. It's a 2.5 million word report. We're trying to figure out why we are in Vietnam. What can we do to improve our standing? What can we do to get more people to support us? They create this report called the Pentagon Papers. It is classified, so that means that this leaks. And within 3 years, the New York Times, the Washington Post, they have the full report. Well, they call the executive branch, they call President Nixon and say, hey, this report's been leaked to us. We're going to start printing it daily. We're going to print out a few pages each day for the people to read. Well, the executive branch says, no, you're not. Under Section 793 of the Espionage Act, the Attorney General says this is cause, and they sue the Times, they sue the Post, say you cannot publish any of this information. The papers say, yes we can, freedom of the press. Who is right? Can the executive branch, can the federal government say, no, you can't do this, violation of federal law, could put people in danger, or does freedom of the press trump that? 6-3 decision. The court says, nope, no prior restraint is allowed. The freedom of the press trumps the Espionage Act. It trumps prior restraint. Federal government, you cannot censor or you cannot punish them before they actually publish the material. So the Times was allowed to publish this material. This last case, I'm sorry, I apologize, my animation is wrong. But this last case is called New York Times versus Sullivan, 1964. Once again, date is important for context. 1964, we were involved in civil rights movement across the United States. 1950s, 1960s. Well, in the 1950s, 1960s, segregation is a way of life. However, it is being fought. The South is slowly being forced to desegregate. The South doesn't like it. We see a bunch of peaceful protest by individuals, peaceful marches, sit-ins, this kind of thing, to protest the way African Americans are being treated in the southern states. We have freedom riders, freedom, F-R-E-E-D-O-M, riders, R-I-D-E-R-S, coming down from the north. They're coming down from the northern states to join the protest, these peaceful protests. And we have northern newspapers sending reporters down to report on these peaceful protests, to report on what's happening in the South. How do you think the South looks? How do you think the southern states look in these reports? Not very good. So, these reports are being filed by the northern newspapers. These stories are being written and published. They're making the southern states look bad. So in an effort to prevent these stories from being told, from being published, the southern states start to sue the newspapers. Say, if you don't retract, if you don't take back this story, we're going to sue you. Well, of course, newspapers don't want to get sued, so they start retracting stories. Well, the New York Times writes well, they have this full-page ad. It is a picture of Dr. Martin Luther King, and it's the picture, and it's basically the first GoFundMe effort that we ever see. Mr. King has been arrested during his peaceful protest in Alabama, and the New York Times is trying to raise money for his defense. So they print this picture of Dr. King. They write this article that's called "Heed Their Rising Voices." And in this article, it's talking about Mr. King and his peaceful protest. And it says things like, he marched from the church on Elm Street over to the church on Smith Street. When they arrived at this church, they sat on the steps of the church and sang Amazing Grace. He was arrested at this location. It was his fourth arrest. They're giving little facts like this. Well, Alabama has this law for libel, that if you are saying something that is false, you can be sued. Well, Mr. Sullivan, he is approximately the acting state police chief. He contacts the New York Times and says, "I've read this story that you wrote on Dr. King. There's some falsehoods in it. I am informing you that there are falsehoods in it. I'm informing you that it makes me look bad. If you don't retract this story under Alabama law, I can sue you." The Times says, "Let us check into it. We'll get back to you." The Times checks into it, and they do call Mr. Sullivan back and said, "Well, you're right. There are some falsehoods. But it's things like we got the street name wrong. They walked from Elm Street to Oak Street, not Elm Street to Smith Street. We got the name of the hymn that they sang wrong. You're right, he wasn't arrested for the fourth time, he was arrested for the seventh time. So yes, there are mistakes in here, but they are minor, inconsequential mistakes. And as far as making you look bad, Mr. Sullivan, you're not even mentioned in this. This is in no way, shape, or form makes you look bad, so we are not going to retract the story." Mr. Sullivan says, "Okay, thank you, appreciate it. I gave you the chance." He sues an Alabama court. He wins. Alabama court awards him $500,000. The Times says, "We're not going to pay this." So they appeal the decision. The appellate court upholds the trial court decision. They say that the Alabama court was right. So the New York Times appeals to the Supreme Court. They say, hey, under First Amendment freedom of the press, we have the right to do this story. The Supreme Court says, okay, when we're looking at these stories, when we're looking at these falsehoods, if they're falsehoods, what are the reasons behind it? We have to look at something called actual malice. Are they telling these lies with the intent to harm or with the intent to impugn somebody's character? So what the Supreme Court says in a 9-0 decision, that freedom of the press, it protects publication of all statements, even false statements, if there is no actual malice. If this statement was not made, if this falsehood was not made to hurt somebody's character, it is okay, it is covered by freedom of the press. So 9-0 decision, they said the lower court decision was incorrect. The New York Times was able to publish this. So this deals with actual malice. Second Amendment, the right to bear arms. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What does this mean? It depends on who you ask. A lot of people read the first half and say a well-regulated militia being necessary to the security of a free state. They stop there and they say this means you need to be in the militia to have firearms. Other people say the right of the people to keep and bear arms shall not be infringed. To them, this means that you're allowed to have whatever you want. Well, two groups, two different definitions, and whatever definition they think actually doesn't matter. The definition of the Second Amendment, the decision about what it means. Who is the only one that matters? Whose decision is the only one that matters? That's right, the Supreme Court. And the Supreme Court has ruled on Second Amendment right to bear arms. They state that the Second Amendment does protect the right to own ordinary militia weapons. So we as individuals have the right to own, we have the right to keep ordinary weapons. But if there is a classification of ordinary weapons, does that mean that there would be a classification of extraordinary weapons? Yes. The Supreme Court has ruled certain weapons are not ordinary. This means that while yes, we the people are allowed to keep and bear arms, we are not allowed to have any weapon that we want. The Supreme Court has ruled that the government can place reasonable restrictions on gun ownership. So yes, we have the right to bear arms, but not all arms, and the government can place restrictions on ownership.